And the thing you have to know about the Supreme Court, it's a great courtroom. If people haven't been there, you should make a special trip to Washington and sit in one of the arguments. Part of what makes it a great courtroom is that there's this real feeling of intimacy. And you almost feel when you're at the podium as an advocate as if you reached out your hand and the judge reached out her hand, you could touch in the middle. I mean, that's how close you are. So you get up to this podium and there are 9 people and they're all around you and they're right in your face. And it's a kind of special, awesome, thrilling, for the first time, a bit scary feeling.
What was your first argument?
Well, my first argument was an argument that has become a little bit famous. My first argument was the re-argument of Citizens United. So if you remember Citizens United, which was a case about the permissibility of restricting corporations' expenditures during election seasons. And the case had been argued in the spring just as I got to the Solicitor General's office. So I got to the Solicitor General's office confirmed, sometime in March. And the case was originally argued just a couple of days later, and it was argued by one of my deputies at the office. And he had done the argument. I think people thought that the administration would lose. The administration was, the Solicitor General's office was on the side of defending the constitutionality of the statute, which is something that the Solicitor General's office typically does when Congress passes a statute. Except in very unusual situations, the job of the Solicitor General's office is to defend the constitutionality of that statute. And he had done an argument trying to defend the constitutionality of the statute. I think people had come away from the argument thinking that the application of the statute to the particular case would be struck down, that the court would hold that that application was unconstitutional. But instead, what the court did was at the very end of the year, it issued an order setting the case for re-argument and asking the advocates to address some much broader issues about some prior precedents that the court had decided about campaign finance regulation generally. And I think, most people who sort of understood the way the court works understood pretty well that the court was getting ready and was probably going to reverse a couple of precedents and really sweep away a number of the campaign finance regulations that were involved in the case. And so I did the re-argument. The next fall was a special session. Usually the court starts in October, but because it was a re-argument, we started a month early. And there was a lot of attention on the case. Everybody knew it was going to be an important case. And so on the one hand, it was very nervous-making because this was a hot case and everybody was paying attention to it, and it was important. The constitutionality of some significant pieces of congressional legislation was at issue. But on the other hand, I think sort of basically everybody said to me, you know what, you're going to lose. You could get up there, you could do the most brilliant argument in the world, and this cake is baked. And so that took a little bit of the pressure off. There was enough pressure, but it took a little bit of the pressure off, that feeling of, in the end, this argument isn't going to make all that much of a difference. So I got up there, and I was pretty nervous, as you are when you're doing something for the first time, and you're doing it in a very high-profile public setting. And I remember, my heart was beating a little bit fast, and then I got up to the podium, and as is our wont at the Supreme Court, the questions started flying fast and furious. They barely let me get a sentence and a half out before the first question came. I remember very well what the first question was. I don't remember what I was saying, but I was saying something. I was really about 2 sentences in. And honestly, truly, this is pretty typical for our court, as your students found out yesterday.
And we'll
So
remember.
it's,
We'll
yeah,
remember.
I was about 2 sentences in, and whatever I said, Justice Scalia said, "No, no, no." So I had to say something to that, right? And you know, honestly, then what happened was I did say something to that, and we carried, and I thought, look at this, words are coming out of my mouth. Seems okay. And after that, I really had a very good time. And I continued to have a good time every time I argued. It's really challenging. It's very fast-paced, as your students learned. It's very fast-paced, and they throw the hardest questions they have at you. They don't come to throw the softballs at you. We pitch the hardest questions we can, and you're trying to think on your feet as quickly as you can, and it's exciting, and sometimes you do it a little bit better, and sometimes you do it a little bit worse, but actually all the time it's a lot of fun.